Welcome to the Supreme Court Show. In this video, I'm going to be talking about Cameron v. EMW Women's Surgical Center. The opinion was issued in March 3rd, 2022. I just want to briefly discuss my intention with this video. I want to briefly present the main issues the Supreme Court's discussing and provide the main arguments from each Supreme Court justice. I don't intend to discuss every nuance of the arguments. If you would like to read the opinion in detail, I'll link it in the description below. And with that, let's go ahead and get into the case. The petitioner for this case is Daniel Cameron, the Attorney General of Kentucky, and the respondent is EMW Women's Surgical Center. So the story goes that the Kentucky legislature adopted a bill that regulated a particular abortion procedure. EMW Women's Surgical Center, a clinic that performs abortions, filed this action in federal district court seeking to enjoin the enforcement of the law. The complaint named among the defendants the Attorney General and the Secretary for Health and Family Services. The plaintiffs agreed to dismissal without prejudice of the claims against the Attorney General. However, he reserved all rights, claims, and defenses that might be available to him, and specifically reserved all rights, claims, and defenses relating to whether he is a proper party in this action and in any appeals arising out of this action. He also stipulated that any final judgment in this action concerning the constitutionality of the bill would be binding on the Office of the Attorney General, subject to any modification, reversal, or vacation of the judgment on appeal. The district court found the Kentucky law unconstitutional, and while the appeal was pending, Kentucky held its 2019 general elections, and the current Attorney General, Andrew Beshear, won the race for governor. Then Governor Beshear appointed a new Secretary for Health and Family Services. This new secretary continued defense of the challenged law, and Attorney General Cameron also entered an appearance as counsel for the secretary. On appeal, the Sixth Circuit affirmed. Within a week after the decision, the secretary informed the Attorney General's office that he would not file a petition for rehearing en banc or a petition for a writ of certiorari. The secretary would also not oppose the Attorney General if he moved to intervene for the purpose of seeking further review. About a week after the decision, Attorney General moved to withdraw as counsel for the Secretary and moved to intervene as a party on behalf of the Commonwealth. The Sixth Circuit did not permit Attorney General to intervene for three reasons. One, it was untimely. Second was that there was no substantial legal interest at stake. And third, allowing intervention would prejudice the respondents. Justice Alito delivered the opinion of the court. The issue was whether the Sixth Circuit should have permitted the Attorney General to intervene. The Supreme Court held in an 8-1 vote that the Sixth Circuit should have permitted the Attorney General to intervene. And the reasoning goes, first, Justice Alito looked at the respondent's argument that the court lacks jurisdiction. The respondent argued that because the Attorney General agreed to be bound by the judgment, he could have filed a notice of appeal. But since he failed to do so within the time allowed by law, his motion for intervention should be treated like an untimely notice of appeal. The argument fails because no law limits jurisdiction of the courts of appeals in this way. So after briefly discussing that, Justice Alito moves on to discuss how there's no rule that provides a general standard to apply in deciding whether intervention on appeal should be allowed. Because of this, he will consider policies underlying intervention in the district courts, including the legal interests that a party seeks to protect through intervention on appeal. Part 1 of the analysis, states retain a residuary and inviolable sovereignty. So this section discusses the relative power between the federal and state governments. Paramount among these retained sovereign powers is the power to enact and enforce any laws that do not conflict with federal law. A state's opportunity to defend its laws in federal court should not be lightly cut off. The Secretary chose not to litigate this case further. By keeping the Attorney General from intervening, the state would not have an opportunity to defend their law in federal court. Importance of ensuring states have fair opportunities to defend their laws in federal court has been recognized by Congress in the past. Part B of the analysis begins with the Court of Appeals' assessment of timeliness was mistaken. The rule in general is that timeliness is to be determined from all the circumstances, and the point to which a suit has progressed is not solely dispositive. Although the litigation by that time had proceeded for many years, that factor is not dispositive. the Attorney General's need to seek intervention did not arise until the Secretary ceased defending the state law, and the timeliness of his motion should be assessed in relation to that point in time. The Attorney General sought to intervene only 2 days after learning that the Secretary would not continue to defend the law. So the time to measure it by was 2 days, not the years of litigation like the Court of Appeals said, according to Justice Alito. Part C of the analysis begins with how the panel argued that intervention would prejudice respondents because the Attorney General's rehearing petition pressed an issue that had not been raised in the Secretary briefs. The issue raised in the Attorney General's rehearing petition, as opposed to the one filed by the Secretary, was immaterial, according to Justice Alito. The respondents argued that intervention would unfairly deprive them of a reasonable expectation stemming from Governor Beshear's recent election. They reasonably expected that the new governor would appoint a secretary who would give up the defense of the bill. However, according to Justice Alito, there is no legally cognizable expectation that this would be the case before all available forms of review had been exhausted. In conclusion, the court reversed and remanded this case. Justice Thomas concurred. In Justice Thomas's analysis, another reason why the respondent's jurisdictional argument fails is because Federal Rules of Appellate Procedure 3 and 4 permit only parties to appeal a district court judgment, and the Attorney General is not a party to the judgment after he was dismissed from the litigation early on. Because the Attorney General was not a party to the district court of the district court's final judgment, respondent's jurisdictional argument necessarily fails. As a non-party, the Attorney General could not notice an appeal under Rules 3 and 4. This undermines the respondent's argument that the court lacks jurisdiction. Cameron's motion to intervene was his only legitimate option to participate in the appeal as a party. For this reason, as well as those given in the opinion of the court, the respondent's jurisdictional argument fails. Justice Kagan, with whom Justice Breyer joins, concurred in the judgment. In Part 1 of the analysis, the rules discussed how the losing party must file a notice of appeal within 30 days of the entry of judgment, and this is deemed a jurisdictional rule, whether a court has jurisdiction or not. EMW contends that the Attorney General, though a non-party, could have appealed the district court's judgment because it bound his office in that stipulation. The motion to intervene was not an attempt to escape the consequences of failing to adhere to appellate deadlines. Rather, it was a response to a major shift in the litigation, creating a new demand for the Attorney General's participation. And in Part 2 of the analysis, it's discussed that there's no need to discuss this argument in constitutional terms at all. If the Attorney General could not assume the defense, Kentucky could no longer enforce its statute. Therefore, a state has a significant interest in enforcing its own laws, and the Attorney General belonged in the suit, absent some very good cause to exclude him, and no such cause was present in this case. Justice Sotomayor dissented. It's discussed the Court of Appeals' denial of Attorney General's motion to intervene is not an abuse of discretion. The Attorney General's change in position alone requires affirmance, and by change in position, Justice Sotomayor is referring to his change of views from the district court and the different view he had in the appellate court. In the Court of Appeals, the Attorney General sought to intervene to ensure that the state's interests with respect to the bill were fully defended. However, in the district court, the Attorney General had no interest in the case because the bill does not confer upon the Attorney General the authority or duty to enforce the provisions as enacted. A state official's late-breaking effort to change his theory of state law comes with costs to judicial efficiency and finality, and it disrupts the expectations not only of the adversarial litigant, but of other parties who may have litigated based on their understanding of both the state's position and who would represent the state's interests. Justice Sotomayor calls this a two hats theory, and that the court has never held that a state official can wear separate hats within his official capacity with different legal effects based on both. The court's decision to allow intervention on appeal is without precedent. However, the Ninth Circuit has previously denied intervention on facts very similar to these. Because perhaps the court means to excuse the Attorney General from his prior stipulation because of the unique circumstances when there was an election in the middle of the litigation. However, this reasoning can apply if the Attorney General had held office at the beginning of the lawsuit, made a calculated decision to stipulate to dismissal and let another state officer take the lead, and later sought to re-enter when that officer decided not to pursue further appeals. So Justice Sotomayor believes that this holding will allow people to abuse the system, which will cause inefficiency in the courts. And lastly, Justice Sotomayor ends with the more specific framing of the issue than the majority, and the issue is framed like this: whether the Court of Appeals acted within its discretion by denying this Attorney General leave to intervene when his office previously stipulated to dismissal on grounds that contradicted his argument for intervention. So it was an 8-1 decision, and that's the opinion for Cameron v. EMW Women's Surgical Center. Thank you for watching, and I'll see you in the next opinion.